Okay, I think we are started.
Hello, all. My name is Aaron Hall. I'm here today with fellow attorneys at Joseph and Hall, Jennifer Howard and Rylan Warner, for this week's update. And we just have a couple of things that we wanted to provide updates on. And then we will get to your questions in the comments. So if you have them, you can post them now, and we will try to get to all of them. And I think with that, Rylan, you want to give start with your update?
Sure. So last September in 2020, the Department of Homeland Security announced that they were going to revise what they were going to do with biometrics appointments. And so if you're not familiar with biometrics appointments, anybody that's getting an immigration benefit or trying to naturalize, they have to go in to an office and they take their fingerprints, they take a photo of them, and they sign. And it's all primarily used for a background check on that person, just to run it against criminal databases, see, hey, if we missed anything regarding that individual. But what they wanted to do with this proposed rule back in September, they were going to expand how they were going to take biometrics from people. So they were going to start taking palm prints in addition to fingerprints. They were going to start using facial recognition software on the photos of people. They were going to also take special pictures of people for their irises to get special, iris fingerprint type things from people. They were going to start taking DNA from people, and they were also going to try to take voice prints from people, which I had not heard of before. And they were going to use all this to do the background check, but they also wanted to increase what they were going to potentially do with all this collected information from people. And they were going to potentially use it for any enforcement of immigration laws. So it would be stored in this database to be used in the future as well, not just for background checks. And so this was, kind of a controversial thing. I mean, there have been a lot of conversations about facial recognition software and how it can be racially discriminatory and biased. And so a lot of people left comments on this proposed rulemaking, and they decided, you know what, we're going to backtrack this, and they withdrew the entire thing. So they've gone back, and thankfully we will not have to be going in for these rather intensive biometrics appointments. They're just going to keep them as is for now. So that's a really good thing. I'm excited about it.
That's a creepy future, even though it's averted for now. It's a little bit scary.
Yes, I don't even use 23andMe, so I can't even imagine this.
Yeah. All right, well, I will move on to my update. So I wanted to talk a little bit about processing times at USCIS. So since the start of the pandemic, at one point, USCIS offices were basically shut down for a period of months, and then they started to reopen with very limited appointments, and they were trying to limit the numbers of people in any field office, and really we're focusing, at least at first, on naturalization interviews over any other kinds of interviews that they had to do. Through that, obviously, with not doing interviews and doing more limited interviews, there's been kind of a backlog that's built up, and we don't really know what that's going to mean. So I wanted to take a walk through some of the processing times as they're posted right now and talk about what people can expect for their applications going forward, which is short answer, we don't know. But for example, an adjustment of status application. So this is for somebody who's applying to get their green card here within the United States. If it's going to be adjudicated at the Denver field office, their processing times are posted as 12.5 to 25 months, so a little bit more than 2 years. The horrible thing about that is, until you get outside of that 25 months, they won't even really listen to an inquiry about the status of the case. They won't give you any kind of update. And 2 years is just an unconscionably long time to wait for the adjudication of what should, in a lot of cases, be a pretty simple benefit request. But that's what it is. Now, the I-751, that's an application for people who are conditional permanent residents to remove the conditions from their status. And it's usually filed by mail, and then you wait for either a decision or an interview to be set. And for those applications filed with USCIS and then adjudicated by field offices, they say it can take from 17 to 35 months. So we're talking about nearly 3 years just for them to make a decision on a petition to remove the conditions. An application for naturalization done at the Denver field office is 7 to 13 months. And an I-90, which is just to renew a green card for somebody who already has their permanent resident status, that is 4.5 to 10.5 months right now. So in all, I think the takeaway is that these processing times are pretty long. And we don't know if they're about to get worse with the flood of applications that kind of were shelved while the offices were closed and at limited capacity. Where does that leave you? Well, one thing that people obviously can do, and most will do, is just to wait and make inquiries when they can, and hope that their benefit request will be adjudicated as soon as possible. For some people, there's more urgency than that for one reason or another, and they can't wait or don't want to wait. And that's where you really get left in the situation of considering filing a mandamus suit against USCIS, asking for a judge to order them to adjudicate the benefit, saying that it's taking unreasonably long. And that's something, if you wanted to consider, we would definitely encourage you to contact our office and do a consultation about. Because just because they say that 35 months is the expected processing time, that sure doesn't make it reasonable. And so it's something that just requires a little bit of analysis. And many times there is a possibility to move the case forward faster through litigation. So that's what we're looking at there. A lot of uncertainty about what's going forward. We hope but don't know that they have plans to reduce that backlog and make things go faster. But we'll just have to see how that goes. Jennifer, let me pass it on to you for an update on employment authorization documents.
Okay, perfect. So we have some good news that came out, I guess, let's see, today's 13th. On the 10th, so a few days ago, that DHS, the Department of Homeland Security, is withdrawing a rule that they proposed back in November of 2020 that would have eliminated employment authorization eligibility for people with final orders of removal that are on orders of supervision through ICE. And so an order of supervision, for those that don't know, is for someone who is being monitored by DHS, by ICE, because, for example, they may have been ordered removed by a judge, but they can't get a travel document or a passport to go back to their country. This happens a lot with asylum seekers. And so they're placed under supervision. Sometimes that means ankle monitors. It usually means check-ins on designated dates with ICE. They are supposed to try to continue to get a travel document or passport, and they have to present themselves for removal once ICE is actually able to remove them. So previously, people in this situation have been able to get work authorization under a Category 4 orders of supervision. And back in November, the Department of Homeland Security announced that they were going to stop giving those people work authorization. So they'd be kind of just stuck in the United States, unable to leave and unable to work. And just recently here, DHS announced that they're withdrawing that rule. So that's really great for people that have final orders, and really great for the businesses that employ those people as well. That's all I got on that.
Great. So it looks like we have some questions. Rylan, do you want to start going through and seeing if we can answer some of those? All right. This is a question from Charlotte. The question is about a potential K1 mandamus lawsuit. And if so, if it's going to happen, when does onboarding start and how much will it cost? Charlotte, I can tell you that we are in the midst of trying to finalize those details. So I don't want to get out ahead of anything. and commit to something that we haven't decided. But we are going through a draft FAQ, and we expect to have more information for everybody about a K1 mandamus lawsuit for the London consulate in the coming days.
1 second. There we go.
Marcos with a question on when will the motion for summary judgment be filed in the case of a positive ruling? Will plaintiffs be prioritized? FYI, I'm EB5 petitioner from Brazil. The question about whether plaintiffs will be prioritized, Marcos, is yeah, I mean, typically they will. Now, we can't guarantee the way that a judge's order is going to read. And so we can't say for sure that the order is going to say, you know, plaintiffs must go first. But in general, they're prioritized, and this is why. When the judge issues an order and there's named plaintiffs in a suit, normally there's going to be some kind of follow-up on that order, whether it's a status report or a status conference that's going to have to happen before the court in the wake of that order. And what the government attorneys don't want to have to do is go back after the initial order is given by the judge and explain to the court why none of the named plaintiffs' cases have moved. And for that reason, there's pressure to move those plaintiffs first, because they're going to have to report to the court about what's happening with their cases. And for that reason, yes, named plaintiffs are typically prioritized out of the order coming out of the court. As far as when the motion for summary judgment will be filed, I don't have that off the top of my head, and so I'm not exactly sure of the timeline. Rylan and Jennifer, are you?
No,
okay.
I'm not quite sure about that either.
Okay. Yeah, so I just don't have that one off the top of my head. Sorry, Marcos. All right, question is for news on the Penn lawsuit. The Penn lawsuit is about the Brazil K1s. Jennifer, do you have any update on that?
Yes, so we filed the amended complaint in that last week, and we are still waiting on government response to the original complaint and for a U.S. attorney to be assigned. So.
All right. Bartek, DV 2021, I want to enter on an NIV and spend a few months in the US and then come back for consular processing. Can I stay and file the AOS towards the end of the fiscal year using slow processing as a reason? First of all, hello, Bartek. I think we've spoken before. Nice to hear from you. So what you can't do is come in on a non-immigrant visa with the intent to adjust status. And so the short answer is no, that's not a plan that will work. Now, sometimes people are here in non-immigrant status and circumstances change, and that change of circumstances leads them to change the way that they're filing for their permanent resident status. So instead of returning to consular process, they choose to do an adjustment of status. Those kind of decisions and whether they're appropriate are very, very circumstance specific. I wouldn't be opining about whether that would work for you, just over the course of a video call like that. So I guess the short answer is just no, you can't come in with the intent to adjust status. All right, Charlotte again. If we're already in Kinsley and join London K1 mandamus, then we get priority with Kinsley. Would we get our money back from London K1 mandamus? That's something that I'm not sure whether will be addressed directly in the FAQs that we're going to be released, but the answer is no. I mean, once the K1 mandamus lawsuit is filed, then the work that's been done to try to move the case and to bring the litigation has been done. And so there wouldn't be a refund just because later the result came seems to have come as a result of something that happens in Kinsley rather than the London K1. NVC is not sending cases to the London embassy. What can be done about this? Well, that's part of the reason that why the London embassy may need to be sued. The NVC, so both parties, whatever the consulate is and the National Visa Center, tend to point the fingers at each other and blame each other. But the way that it actually works is that the embassy informs the National Visa Center of when they have availability to schedule interviews. And the NVC is not going to send it until they get that notice saying that they have availability to get it done. So it's probably more of a problem of the London embassy rather than the NVC. Short of litigation, we say that when you contact the National Visa Center and whatever consulate you're dealing with, you should copy both parties, both the National Visa Center and the consulate, on the same email, just to make it more obvious and ridiculous if they're both pointing the fingers at each other. They can't both be the problem. One of them, either the NVC is not sending the case when it should, or the London consulate is not accepting the case when it should, and one of the two has got to be the problem for the delay. So to avoid them pointing at each other, I would copy both and then point it out if their answers are contradictory. How long do I think the wait is for an interview at the London embassy? I don't know. Sorry. All right, Danielle, if we are on the Kinsley case, do you recommend joining the possible London mandamus too? All right, so it's a good question, and I want to back out for a second and talk about what the difference between the two is. So Kinsley is not and was never going to be a mandamus claim. Kinsley asked for an order saying that they could not use regional bans to stop processing and issuing visas. And what the London case would be a mandamus case. A mandamus case means you're asking the court to order the government to do its job. The government has a job for visa applicants who have paid their fees and submitted all their documents. They have a duty to adjudicate the visa application. Where they've failed to do that and the failure has been unreasonable, the delay has been unreasonable, then a court can order them to do it in a specific amount of time. And so the new possible London mandamus case would be that, which is not what Kinsley is. And so, if you're able to do so, even if you're a Kinsley plaintiff, you may want to consider joining the possible London mandamus case. I will let you know, Danielle, and everybody else who has questions about this. These concerns and questions will be addressed in writing in the FAQ that will be available, like I said, in the next day or so, I think. Gus asked if we can see a copy of the government's motion to dismiss that was filed last week in Milligan. I wasn't aware whether one of those had already been sent out. The only thing that we have to do usually, Gus, is before we email that out to plaintiffs, is make sure that any information that may need to be redacted is redacted. But I will check with the folks who are running point on Milligan and see if it's already been redacted, and if so, if we can send that out. But yeah, that'll be no problem.
Now, for this question, I know that you said that there wouldn't be a refund, but are we considering any idea of a discount?
I don't know that yet.
Okay. And that's the final comment question. A little bit slower this week. We're usually barraged with nonstop questions.
Well, no, that's good. I mean, I think hopefully a lot of the questions that relate to Kinsley and the K1 in London will be addressed in the FAQs that are coming out. Let's see. I see one more question coming from James Kennard saying, is there a redacted copy of the Penn v. Blanken suit available for plaintiffs? And I'll give you the same answer, James. That shouldn't be a problem. I just don't know off the top of my head if it's been redacted yet. If so, we will we will be happy to send that out to the plaintiffs, and I will check on that this afternoon.
Okay, now that I said that we aren't getting questions, we're getting more questions. So here's a broad one.
Any thoughts on the travel ban between UK and US?
And she adds up for those waiting for approval still.
Yeah, do you know what she's referring to? Either of you?
No.
Yeah. Hannah, I'm not sure what you're referring to exactly. So I don't know how to answer that one. But yeah, if you have, Hannah, if you have other parts of that question that you want to do to clarify, you're welcome to contact me, but I don't know.
Oh, here we go. Here's follow-up. U.S. border is closed to UK residents waiting for K1 visa approval.
Yeah, I'm not sure what that is. Is this a new announcement that's come out like today or something?
I haven't seen.
I don't know.
Okay, in the meantime, here's one from Lydia, which is we're all confused about.
Okay, thanks, Lydia. So I don't have the updates on individual people from Milligan, but my understanding is that the cases are continuing to be processed. That we are getting down to only a handful of people from Milligan who still need to be interviewed and have their visas adjudicated. So that's where that stands. Any updates that we have, I think, are for problem cases or consulates that are being communicated with the government attorney by Jeff Joseph here at our office. And so I know that not everybody's gotten it yet, but I think we're getting pretty close. So John says he understands that there was never mandamus in Kinsley, but that there was a suggestion that there could be prioritization for plaintiffs. Would it be worth waiting to see what happens before joining a London mandamus? That's all about weighing your own circumstances. Yes, it could be that whatever comes out of Kinsley means that cases including people in London are prioritized and move up. It could be that joining the London mandamus makes it happen faster. There's just no certainty there. If you're looking to have all bases covered and make sure that you're included in a case that's specifically a mandamus, then you have to join a mandamus case or file a mandamus case. Otherwise, yes, of course, you can wait and see what happens with the Kinsley order. So the question is, who should they give direct questions to on the Kinsley case? I'm not sure what the different answers that you're referring to are, Tandy. As far as the question about whether Kinsley is going to be a mandamus, it never was going to be, and I think that was in the FAQ, but I'm not sure what questions that you're referring to. Greg has been handling communications in a lot of the cases, and is certainly one of the lawyers that's very involved in the Kinsley case. We also at our office have been very involved in the Kinsley case, and so lawyers from either firm should be able to get you correct information. All right. If at London Embassy for K1 and not part of the mandamus, will I go behind plaintiffs? I don't know. Linda, I'm sorry. There's no way to know exactly how that'll play out. No one can. Okay, so is this what? I think this was what was referred to.
Hannah, what Hannah was referring to.
Oh, okay. But I think that Hannah, maybe I misunderstood, but I think that Hannah was talking about K1s, which which fit into the national exemption requirements. So that shouldn't be in effect. I thought she was saying that there was some kind of new ban on K1s, and that's why I said I didn't know. But yeah, these are issues where there's already a national interest exemption that's been granted, so that shouldn't stop K1s from entering once they have their visas.
So she was saying there's some difference in treatment between K1 applicants versus K1 visa holders.
Yeah, I mean, I don't understand the question because the K1 applicants, I don't understand how they would be analyzed for entry as opposed to visa holders. You'd have to have the visa in order to come in unless you have another kind of visa.
Mm-hmm.
Do you think K1 visa applicants any other relief from Kinsley, in your opinion? I think that's what we're asking for. We're asking for ultimately we want their cases to be processed without any taint from the regional bans or the no visa policy. Whether that translates into a judge saying, government, you must adjudicate these named plaintiffs from Kinsley, that we don't know yet, because the government will certainly argue, hey, it's moot because these proclamations aren't being used against them anymore due to the national interest exemption. Abadir, I'm not sure which case this refers to, but the briefing schedule would be set by the court. So it depends on the deadline set by the court. What about DV 2021? That's what the Go case is about. And so the schedule has been set out in Go. We are asking for all the visas to be reserved. We're asking for our plaintiffs to have their visas adjudicated before the end of the fiscal year. And if it's not possible, then that they should reserve visa numbers, all 55,000, to make sure that our plaintiffs have the opportunity to immigrate to the United States as DV 2021 winners.
Oops. Did you want to say more about that?
No. You can go on to Abdul Wahed.
So this is the one that I actually submitted. So I have been keeping closer track of this one, and I called. So we sent in the complaint. It has been served on the civil process server and at the U.S. Attorney's Office in DC, and we've been sitting and waiting for it to be actually assigned. I called this morning actually to see if it had been assigned to a U.S. attorney, and it has not yet. So we are just waiting right now to hear back about that.
When is the hearing for Kinsley? I'll have to pull that up. I'm sorry, I don't know off the top of my head. Looks like there's one more. Do you see the one from Bartek there?
Oh, yeah. Move forward.
All right, so this looks like our last one. Is the risk of being denied entrance on existing B1, B2 significantly bigger after filing the DS-260 and showing immigrant intent? Yes, I mean, it's definitely going to be taken into account. So I do think that it's significantly bigger. That does not mean that it's impossible to enter on a B1, B2, but you will have to convince them that you have a specific reason for your entry and that you have a specific plan to leave and continue with the consular processing. Whether that's possible in any given case depends somewhat on the officer that you're dealing with. But it is possible to enter on the visitor's visa. It's just that, yes, they will take into account that you have demonstrated an intent to immigrate to the United States. My wedding is May 2022. Do you think I will have my K1 visa by then? It sounds like it was the I-129F was approved this March. I would hope so, Alex. I don't know too much about the case, obviously, about your case. So I would hope that that would be very realistic, but I would just be guessing. All right, Jennifer, do you want to take a crack at a CSPA question?
So I actually just did like 5 calculations on this about an hour ago. Age gets frozen, applicant priority date. Okay. So you're asking if it's 1 at the priority, when the priority date becomes current, or 2 at the interview date. It's not the interview date. Let me actually pull up. It's a really fun calculation. It's actually on the visa bulletin, it's the filing date, that chart, that second chart, not the final action one, but the filing one. And you have to look at, I think it's the soonest, or sorry, it's the latest of whenever the case was approved, the I-130 was approved, or the filing date became current on the visa bulletin, whichever's later. And then you subtract that from the person's age on the date that happened. It's really complicated. It took me like 20 minutes to do it earlier. But yeah, it's not the interview date, if that answered your question, hopefully. USCIS has a good explanation on their website as well. They have like the breakdown and all the different scenarios. If you just go to Child Citizen Protection Act, USCIS, you should be able to find it.
All right. I think that's all the questions. Thank you to everybody for tuning in and asking good questions. We will be back next week with more updates, more questions. The Impact team also has their the Monday afternoon litigation update, so you can tune into that as well. Thanks, Rylan. Thanks, Jennifer.
Thank you.
All right.